The section is manifestly in two parts. Whereas the word used in the first part is may, the second part uses shall. In consequences, the first part gives purely discretionary authority to a criminal court and enables it at any stage of an inquiry, trial or proceeding under the code within bracket A to summon anyone as a witness or within bracket B to examine any person present in court or within bracket C to recall and re-examine any person whose evidence has already been recorded. On the other hand, the second part is mandatory and compels the court to take any of the aforementioned steps if the new evidence appears to it essential to the just decision of the case. This is a supplementary provision enabling, and in certain circumstances imposing on the court the duty of examining a material witness who would not be otherwise brought before it. It is couched in the widest possible terms and calls for no limitation, either with regard to the stage at which the powers of the court should be exercised, or with regard to the manner in which it should be exercised. It is not only the prerogative, but also the plain duty of a court to examine such of those witnesses as it considers absolutely necessary for doing justice between the state and the subject. There is a duty cast upon the court to arrive at the truth by all lawful means, and one of such means is the examination of witnesses of its own accord when for certain obvious reasons either party is not prepared to call witnesses who are known to be in a position to speak important relevant facts. The object underlying Section 311 of the Code is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of the witnesses examined from either side. The determinative factor is whether it is essential to the just decision of the case. The section is not limited only for the benefit of the accused, and it will not be an improper exercise of the powers of the court to summon a witness under the section merely because the evidence supports the case for the prosecution and not that of the accused. The section is a general section which applies to all proceedings, inquiries, and trials under the code and empowers magistrate to issue summons to any witness at any stage of such proceedings, trial or inquiry. In Section 311, the significant expression that occurs is at any stage of any inquiry or trial or other proceeding under this code. It is, however, to be borne in mind that whereas the section confers a very wide power on the court on summoning witnesses, the discretion conferred is to be exercised judiciously, as the wider the power the greater is the necessity for application of judicial mind. As indicated above, the section is wholly discretionary. The second part of it imposes upon the magistrate an obligation, it is, that the court shall summon and examine all persons whose evidence appears to be essential to the just decision of the case.